Mr. Perez and all persons, firms, corporations acting in concert with him are permanently enjoined and restrained from directly or indirectly infringing Take-Two's copyrights, including but not limited to creating derivative works based on any portion of their video games, including Grand Theft Auto V, and producing or distributing any computer programs that alter their games, including without limitation, Elusive, and from participating or assisting in any such activities. Okay, so Take-Two Interactive has obtained a default judgment against, is this spelled correctly? Jonny? Or is this a mistake? I'm assuming this is Johnny Perez. No, it is. It's Jonny. Okay, so it is. Okay, so I wasn't sure for a second. It says it here a second time. Johnny Perez down here. This matter, subject matter jurisdiction, personal jurisdiction, yada, 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 yada. Certificate of default. Okay, so Mr. Perez has been served. He failed to answer or otherwise defend against Take-Two's complaint. Certificate of default was issued November 21st, 2018. He's not a minor, not incompetent, not on active military service. By reason of default, he's admitted the truth of the allegations. That is more or less how it works. If you don't respond to your lawsuit, the lawsuit against you in a timely manner, then you're more or less admitting that the allegations are true, as long as they've been served properly and a couple other things. But you want to respond to your lawsuit. That's very, very important. Respond to your lawsuit. Take-Two has been irreparably harmed by Mr. Perez's infringing conduct and will continue to be harmed unless enjoined. First, Mr. Perez's Elusive program, the infringing program, and this is Elusive with a capital E, so the program is named Elusive, creates new features and elements in Grand Theft Auto which can be used to harm legitimate players, causing Take-Two to lose control over its carefully balanced plan for how its video game is designed to be played. Second, the infringing program harms Take-Two's reputation for maintaining its gaming environment, discourages users from purchases and gameplay. Third, because the infringing program allows its users to create unlimited virtual currency, which can then be used to purchase in-game items in Take-Two's game, it undermines Take-Two's pricing and sales of legitimate virtual currency. These harms are not quantifiable. Take-Two has no way of knowing how much revenue it has lost and will continue to lose as a result of Mr. Perez's infringing program. The balance of hardships favors Take-Two. In contrast to the harm that Take-Two will suffer, there is no evidence of any injury to Mr. Perez. In particular, the inability to continue infringing a copyrighted work is not a legally cognizable harm. Thus, there will be no injury to Mr. Perez caused by entry of a permanent injunction requiring Mr. Perez to cease his infringing conduct. Entry of a permanent injunction against Mr. Perez is in the public interest. Now, therefore, it is hereby ordered and adjudged that under count 1, Mr. Perez is liable to Take-Two for willfully and directly infringing on Take-Two's copyrights. Under count 2, he is liable for willfully and contributorily infringing on Take-Two's copyrights in GTA. In count 3, he's liable for a breach of Take-Two's user agreement. On count 4, he's liable for tortious interference with Take-Two's contracts. And they are asking for Mr. Perez to pay Take-Two the sum of money of $150,000 in statutory damages, which are maximum statutory damages per infringement under the Copyright Act, and $66,868.95 in attorney's fees pursuant to 17 U.S.C. 505, which allows a recovering or prevailing party to recover attorney's fees. And execution shall issue forthwith. Execution means that they can then take this judgment and visit it upon you at the county level and have the sheriff go and take your stuff, basically, or start the process of taking your stuff. Mr. Perez and all persons, firms, corporations acting in concert with him are permanently enjoined and restrained from directly or indirectly infringing Take-Two's copyrights, including but not limited to creating derivative works based on any portion of their video games, including Grand Theft Auto V, and producing or distributing any computer programs that alter their games, including without limitation, Elusive, and from participating or assisting in any such activities. This order takes effect immediately. The court shall retain jurisdiction, and the clerk is directed to terminate the motion for a default judgment. Honorable Kevin Castell, United States District Judge, 4 February 2019. So that's interesting. Now, the question from me, the biggest thing I was wondering is how much money did Mr. Perez allegedly make from Elusive? It's possible that $150,000 plus $66,000 is less than that. So it may have been a good decision not to appear for court and get a 150 plus 66,868.95 $217,000 judgment. For all we know, Mr. Perez may have made way more money off of that, and $217,000 might just be the cost of doing business.
Just quickly, from the article that I originally grabbed this from, it was saying that he accepted his guilt in it and wasn't instructing, but saying that Take-Two could pick out any charity and he will donate the money to it. But that's probably why he decided not to respond to it, because in his way he admitted his guilt and was happy to pay to charity.
Okay. And it also says here in the side, in the margin, based upon the extent of planning, the intent and the willfulness of Mr. Perez's acts is why the judge found for $150,000 in statutory damages. So now so Take-Two could have argued for more, could have argued that each use of Elusive was a recoverable offense, but that's going to be a harder argument. They went for the easy argument that one count of maximum statutory damages plus attorney's fees would be enough. So what do you think? Would you be deterred from making a cheating program if you knew that you could get hit with $250,000, slightly less, in liability? Or worse, I guess. And if you got a lawsuit like this, do you think you would consider not responding to it because the maximum damages under the default might be less than maximum damages if they're able to gain discovery and access more information about the case? We've done this before. I have personally advised clients to avoid responding to their litigation when I think they can get away with a better outcome, either on default or maybe the opposing side can't serve them or something like that. So it's an interesting strategy. This could have been part of Mr. Perez's strategy to limit the amount of the judgment by not responding. Even $150,000 might be a lower judgment than he was expecting.
What cost them $66,000 is my question, right? Like if it's a default judgment, that means that they entered their complaint. There was no response for the duration that you have to wait for no response before you enter a default.
Yeah.
So what cost them $66,000 whatever dollars? Like that's very expensive.
So let's just take $65,000 and divide it by an even $500 an hour for an attorney. That's only 130 hours of attorney work. So there might have been some expenses, probably not a lot, but maybe they hired an investigator.
Yeah, that's what I'm
maybe
thinking.
They're adding in all of their hours that they spent evaluating his cheat program. Maybe they're adding in hours that they spent working on an anti-cheat program or something like that. Or, basically, they might have thrown a lot of different things into investigating the case before they decided to sue the guy. And it's high. And a judge would normally scrutinize this when it wasn't a default judgment, but on a default judgment, the judge would probably not scrutinize the bill too much unless it appears outrageous. Lawyers are allowed to charge a reasonable fee, but not an unreasonable fee. And there is a line. If I try to charge $2,000 an hour for representing someone in a custody case, that person who I've represented can later go to my disciplinary board and say I charge an unreasonable fee, even though it's after the fact, even though they signed and agreed.
Yeah, I guess so. I feel like that's a lot of money, and I feel like maybe they made some busy work for themselves, possibly.
However, I'm assuming Elusive was not a free program and that you had to pay Johnny Perez to get access to it. A lot of times these cheat programs are even working off of a subscription model, where you pay a monthly fee to gain access to it, and it has DRM built into itself that revokes the right to access the cheat program if you don't pay. I don't know about Johnny Perez's case particularly.
Kotaku actually theorizes that they had to play GTA and they charged for every hour.
Can I have that job?
Hey, I got paid once to check the courthouse every day, and the 15 minutes it took me to walk down to the courthouse, check, and come back, I charged a quarter hour for each time I checked, and I charged my full rate for it. But the client, we were checking to see if the client was going to get served, and the client was never served. So was that cheaper? That the client paid me several $100s to just check the courthouse on their behalf because they can't walk to the courthouse when they're trying to avoid service? You can't show up at the courthouse when you're trying to make sure that nobody knows where you are.
Yeah, it's like excuse me.
So I'm like, I'll do it, but I'm
trying to serve me. Yes, okay, just wanted to check. Bye now.
So, yeah, you know, probably a slim chance that you'd get served walking to the courthouse and checking something on the computer. But if there was a place where a lawyer would run into you and be like, hey, you're the guy I'm trying to serve. Let me get you those papers out of my briefcase, you know?
Now, question, completely unrelated question, not at all related to what you were talking about. Are there any statutes about avoiding service and how when that becomes illegal?
Not really illegal. You end up paying for the service if you try to duck service and they have to come find you and pay extra money for it. You under the federal rules of civil procedure, you end up paying for it. So like literally a couple $100s for the service. But no, I don't think it's ever illegal. I don't want anyone to take this as legal advice, but I don't think it's ever illegal in the United States for you to attempt to avoid the original service of process. Now, can you mess up your court case later on by doing shenanigans like, oh, I'm going to keep changing my address and not telling the court so they can't? Once you've been served that what we call original service of process, now you're not allowed to play any service games.
Now, I've seen sometimes where the plaintiff will argue that because it's had such difficulty in serving the defendant through traditional means, that they ask the court for permission to serve, for example, by a corporate email, right? So yes. If they're having difficulty, they can ask permission for an easier method to serve you, right?
We saw one where they served via Twitter. The opposing side couldn't be reached via traditional means. However, they had an active Twitter account, and the plaintiff lawyers produced evidence of the Twitter account being active and said, we should have no problem, alerting this person via Twitter. We will use an account that they don't block, and we'll make sure that they get, notice of the thing. And that the judge said that was fine. Basically do a Twitter blast. Here's your copy of your complaint. So you could do it all that. You just need to do that with court's approval. And sometimes the court won't grant that approval unless it's a special case.
That was WikiLeaks.
And we should do some of those stories because those are really fun ones. The sheriff will gather like 15 or 30 names of people who have outstanding warrants that they don't feel like going and getting them from their homes because that's actually kind of dangerous. And what they'll do is they'll say, you've won a free TV. Come down to your local whatever at this time and collect your free TV. And they'll stagger them, come at 10 o'clock, come at 10:15, come at 10:30, whatever. And every one of them walks in the door. The sheriff says, hey, you've won a free TV. Come back behind this curtain. And they go back behind the curtain and get arrested. And the next one walks in and they go back behind the curtain and get arrested. And the next one comes in and they go back behind the curtain and get arrested. And it happens all day. And it's perfectly legal and it's totally legit. And it's one of the safest ways to have people with outstanding warrants get arrested.
See, those probably only work for people that weren't brought up in my age where you had the virus links of like, click here for your free iPad.
Oh yeah, definitely a subset of the population is wise and is like, wait a second, I have a warrant out. I didn't win anything. Sorry. I'll send my sister to go collect it. Yeah, there we go. My innocent sister who has no outstanding warrant. I'll send her to go collect it.
What happens if they send the sister and they
and give her a TV? Well,
do they like have TVs just in case? Like,
oh, I'm sure that the terms and conditions of the giveaway mean that you have to appear in person.
Star asterisk. You must actually be arrested for this to work.
Yeah.
Timothy East says that service via publication can be done. I've never heard of that. Is that something that you've heard of?
Oh yeah, absolutely.
In the UK it was common standard to be served by publication. There will be like certain days of the week where they would publish it. I think it's a lot less common now, but that's how it used to get served. It will get published in the newspaper. You would just look at the section if you were getting served.
So thank you everyone for joining me. That is our show. I am Leonard French, your favorite copyright attorney. This is a community-supported channel. Your money helps us pay for the expenses of the channel. Brandon is now being paid as our editor. Tactical is being paid as our researcher. None of us are making $1 million off of this. We are just using it to offset our expenses, the time that we spend on the show. When I'm busy, Brandon can do all the editing. When I'm not busy, Brandon can do all the editing, and I'll just check it then. And you know, it's great. This is an organization that is growing, and if I have my way, very shortly here, I'll be hiring our tax accountant to start structuring this whole thing in a more 501c3 friendly way, and we'll see if we can't get approved for 501c3. So thank you to all of our supporters in February, especially John Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Jacob Papenfuss. You are all supporting us at the $50 level, and I am very grateful for your support. Thank you very much to the $5 plus supporters who are scrolling on the LED panel behind me, and Brandon will add you during the crawl. I am off to pack for Scotland. I'm going to go visit my dogs for one last time. They're with my parents before I go visit for a week, and of course I'll see everybody when I get back too. But I'll shoot some video of the dogs and see if we can't have some of that included in the videos that drop as well. So love you all. Have a great week. I'll see you in the stories. Don't forget you can join our Discord channel if you want to have interactive discussions in various topics, including those of law, things we talk about on the channel, and off topics. Don't forget that you can tag me on Discord and add stories to our stories bin through Discord as well. And I look forward to seeing you guys next week from Scotland. Love you all. I am Leonard French, and I'll see you next week.